So if everyone is on, scoring panelists and judge, do any of you recognize any of the students on either team?
I do not.
Great. So, and if no one does, then we'll just wait to make sure all the other courtrooms don't have any conflicts, and then we can go ahead and get started. Okay, so we have the all clear. So whenever you are ready, Judge, you can go ahead and get started with pretrial matters.
Just one moment. Good morning, my name is Chris Corkadell. I'll be the presiding judge over today's trial. Is the prosecution ready to proceed?
Yes, Your Honor.
And is the defense ready to proceed?
Yes, Your Honor.
And can we have each team provide us with your team code, or is it just going to be your actual school name or the team name? Todd, and what's the other team? Can the plaintiff please tell us their team name?
It's Oscar.
Thank you. And would the defense please tell us your team name?
It's Todd, Your Honor.
Thank you. And as far as the process is going to go here, obviously this is recorded. You've already had a prompt come up on Zoom indicating that this is a recorded proceeding. So I just want to make sure that everyone does know the Colorado Bar Association may be taking photographs of the competition or screen grabs from this, and that by being here, you are giving them your permission to use those photographs and or screenshots. Is there anyone in here who is not part of the process, whether they're a witness or an attorney? No? Great. There will be no recesses. I just have to remind everybody of that. If there's a health emergency, obviously let us know. We'll be happy to work with that. Let me see. I do need to also change the video settings to hide some things here real quick. And actually, that may be up to the... Ms. Staub, do you have the ability to remove people who are not on video from being streamed? I know that we've done that in the past. Ms. Staub? Okay, well, that's the way that's going to go for now. If we get a chance, we will take care of that. We've already done our conflict check, so we are all good there. At this point, I would ask all team members to please raise your right hands. And team members, do you promise that the presentation you are about to give will be faithfully and truthfully conform to the facts and rules of the mock trial competition? Yes. And witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problems, and that you will follow the rules and procedures of the mock trial competition? See a lot of good nodding. I like that. Gallery members, including teachers and attorney coaches, family members, and friends, please raise your right hand. Do you promise to represent yourselves as a positive role model and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And the last thing is for the scoring panelists. Please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and as objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Thank you. Are there any pretrial issues that need to be addressed before we move forward into openings?
Yes, Your Honor. The plaintiff was wondering if you would like a copy of the stipulations sent in the chat.
I would, please.
Okay, I'll do that in just a second. And also, can our timers screen share our exhibits?
Yes.
Thank you, Your Honor. And one last question. Can we please reserve time for rebuttal close?
Generally, that's asked during the actual closing or right before you begin your closing, but please readdress that later on in the trial.
Okay, thank you, Your Honor. I will send the stipulations in the chat.
Thank you. Any other preliminary issues?
Yes, Your Honor. May we quickly swap computers? We're having some technical difficulties, and then we will proceed with preliminary matters, if that's all right.
Absolutely. How long do you need? Just a couple moments?
Just a couple moments, yes.
Of course.
Thank you.
Unfortunately, the link you sent me for stipulations is restricted on access. Are you able to drop the file itself into the chat?
I can try that, Your Honor. I'm sorry.
Trust me, I've been doing a lot of trial practice. This is a constant issue with all technology.
Your Honor, I was able to copy and paste it into the chat, but I think that's the best I can do. I'm sorry about that.
If there are only 2 stipulations, that is perfect.
Thank you.
My last trial, I think they had 16.
Your Honor, the defense is ready to proceed with preliminary matters.
Absolutely. Please proceed.
So we request that due to the virtual setting, lawyers may remain seated for direct and cross-examinations and objections.
Of course.
Thank you. And we would ask that timekeepers may use their discretion in stopping time in the event of technical difficulties.
Granted. Granted.
Oh, thank you, Your Honor. Your audio cut out a bit. We would also like to establish the means for presenting evidence. Your Honor, given the virtual nature of the proceedings, we request that during the admission of evidence, the witnesses be constructively shown the case materials they have been provided in order to identify them for admission. And then once identified and admitted, and with the court's permission, co-counsel will then publish the exhibit to the jury.
For practical and ease of all the parties involved, the way that I've handled these previously is that the parties may publish their exhibits prior to admitting them so that I can actually review them in time with the parties. It is done as a constructive publication. It's not formally published to the jury until you ask that an exhibit be published to the jury. Does that make sense?
So should we constructively share it to you and the witness at the same time then, Your Honor?
Yes, I would prefer that the exhibits be shown on and through a share screen so that I can rule on any evidentiary issues. And then once you've asked to be the evidence to be admitted, it will be admitted and effectively published to the jury.
Yes, that makes sense. Thank you, Your Honor. The defense has no further preliminary matters.
And just as a follow-up to that, please, you do not need to ask me for permission to show your exhibits. Follow all rules as far as what you need to do for it, but please just put them up and then have your timekeeper take them down when you are finished using them. Do not remain exhibits on the screen after you are done with that witness. Okay.
Thank you, Your Honor.
Any further preliminary matters?
No further preliminary matters, Your Honor.
All right. In that case, would the plaintiff like to make an opening statement?
Yes, Your Honor.
Oh, Your Honor, before we proceed, may we do introductions?
Oh, by all means, please.
Good afternoon, Your Honor. My name is Annie Entner for the plaintiff. I will be directing Dakota Weirs and crossing Skylar Weirs and delivering the opening statement. May my co-counsel be permitted to introduce themselves?
By all means.
Good afternoon, Your Honor. My name is Caitlin Clint for the plaintiff, and I will be direct examining Carson Durst and cross-examining Blake Doncourt.
Good afternoon, Your Honor. My name is Christopher Dudzik for the plaintiff. I will be direct examining Dr. Casey Rogers and cross-examining Dr. Devin Williams, as well as delivering the closing argument. May my witnesses introduce themselves.
Yes, please.
Good afternoon, Your Honor. My name is Sophia Weinicht, and I am Dakota Weirs.
Good afternoon, Your Honor. My name is Luke Brado, and I am Carson Durst.
Good afternoon, Your Honor. My name is Peter Heitman, and I am Dr. Casey Rogers.
Thank you. Would the defense like to introduce themselves?
Yes. Good morning, Your Honor, opposing counsel, and members of the jury. My name is Sahidi Balaji, and today I will be conducting the cross-examination of Carson Durst and the direct examination of Blake Doncourt. I will also be delivering the opening statement on behalf of the defense.
Is there anyone else who'd like to introduce themselves?
Good afternoon, Your Honor. My name is Francesca Kramer, and I will be conducting the direct examination of Dr. Devin Williams, as well as the cross-examination of Dr. Casey Rogers, and I will also be performing the closing statement.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Elizabeth Kugler, and today I will be conducting the direct examination of Skylar Weirs and the cross-examination of Dakota Weirs. At this time, may our witnesses introduce themselves?
Yes, Sammy.
Good morning. I'm Kai Salter, and today I'm Blake Doncourt.
Good afternoon. My name is McKenna Selby, and today I am Dr. Devin Williams.
Good afternoon. My name is Zoe Kugler, and today I am Skylar Weirs.
Thank you. So at this time, would the plaintiff like to make an opening argument?
Yes, Your Honor. Thank you. Good afternoon, Your Honor, members of the jury. My name is Annie Entner, and I represent the plaintiff in this case, Dakota Weirs. Members of the jury, this is a case about one thing: corporate greed. Greed that got out of hand. While a business is certainly entitled to producing a product and making a profit off of that product, they are certainly not allowed to at the expense of their consumers' safety. Unfortunately, Ms. Weirs was a victim of corporate greed. You see, Ms. Weirs was a very active girl in high school. She loved her school and loved helping out in her community. But unfortunately, she also had a job at Havens Landscaping using Lush fertilizer. Ms. Weirs used this fertilizer which contained a chemical called Drufo. Ms. Weirs didn't know that this chemical would cause her cancer, but Lush knew. Lush Fertilizer knew and chose to hide the information. Lush was negligent in their care with Drufo and their fertilizer, and you will hear about this negligence in 3 ways today. First, Lush did not follow the industry safety standard. Second, Lush ignored clear evidence that Drufo was indeed dangerous. And third, Lush did not do sufficient research on Drufo. Today, you will hear about how Lush was negligent from 3 plaintiff witnesses. Each witness will show you how Lush was indeed negligent in their care with Drufo and used a cover-up, which was helping the environment. But as you will hear today, there's a big difference between helping the environment and consumer safety. First, Ms. Weirs will tell you all about her life. Ms. Weirs will start with her extracurricular activities and school activities that she loved doing. Ms. Weirs will also tell you about how she worked at Havens, landscaping, and used Lush fertilizer. A little while later, Ms. Weirs began to feel sick all of the time. Her future was ruined. Her scholarships were taken away from her because of the sickness. Ms. Weirs will also tell you about how Drufo is not used in other countries, thus showing that Lush knew the industry safety standard and chose not to follow it. Second, Carson Durst will tell you about his job at Lush. You see, Mr. Durst worked at Lush for many years and even researched Drufo. Mr. Durst even had a relationship with the CEO. When Mr. Durst found out that Lush was hiding damaging information about Drufo, he quit because he didn't want to be part of a company that hid damaging information. Last, you will hear from Dr. Casey Rogers. Dr. Rogers will walk you through his tests and studies and his conclusions that Drufo is indeed carcinogenic and caused Ms. Weirs cancer. Most importantly, Dr. Rogers will show you how the defense was indeed negligent in their care with Drufo and their studies on Drufo. At the end of the trial today, we will ask you to vote in favor of the plaintiff, Ms. Weirs, because of the preponderance of evidence that the defendant was indeed negligent in their care with Drufo and it caused Ms. Weirs cancer. Thank you.
Would the defendant like to make an opening statement?
Yes, Your Honor. 1 moment to get set up.
Please begin whenever you're ready.
I would also like to ask if the court can hear and see me clearly.
I can. If any of the scoring jurists can't, please let us know.
May it please the court, counsel, and members of the jury. Today's case centers around an unsafe employee, an unconnected illness, and an unbelievable accusation. Lush Fertilizer Incorporated was a company that was founded by CEO Blake Doncourt in 2000. In the time that Lush Fertilizer Incorporated has been a business, the company and CEO have used their success to give back to impoverished communities, protect the environment, and provide their consumers with quality agricultural products that produce results unmatched by any contender. However, today, Lush Fertilizer Incorporated stands wrongfully accused of negligence. Dakota Weirs, the plaintiff in this case, is claiming that the presence of the chemical compound Drufo in Lush's fertilizer has led to her developing non-Hodgkin's lymphoma. But ladies and gentlemen of the jury, that is simply not the case. Lush's own CEO, Blake Doncourt, will tell you that Lush Fertilizer went through several rounds of testing that never turned up any carcinogens. He will also tell you that Lush's fertilizer was formulated with such care and safety that it did not even require a warning label to be put on the product. Now, Dakota Weirs will tell you that she worked with countless chemicals, and many of which she doesn't remember the names of or warnings on them. She will also tell you that she didn't wear the proper protective clothing or use the proper safety equipment to protect herself against those other harmful chemicals. Therefore, claiming that Lush Fertilizer and only Lush Fertilizer could have given her non-Hodgkin's lymphoma is simply unbelievable. Furthermore, you will hear from Carson Durst, who claims that Lush's business practices were unsafe and were done to protect the face of the company. But Mr. Durst will also tell you that he received mounting complaints about his job performance from his coworkers, and his research is not supported by anyone else at the company. Mr. Durst will also admit that he did not have access to all the research and data that Lush did into Drufo. Additionally, the plaintiff's expert, Dr. Casey Rogers, will try to tell you that Drufo indefinitely leads to cancer based on a study that he did, where he compared fertilizer effects between farmers and ordinary individuals. However, the defense's expert, Dr. Devin Williams, will tell you that farmers handle fertilizers much more frequently than the average human, and comparing the two is akin to comparing apples and oranges. Dr. Williams will also give clarity on the reasoning behind Drufo being banned in the EU. She will tell you that the studies done to reach the conclusion of the ban were biased, as the results show how Drufo reacts in a lab, but not in the environment, which is where Drufo is used when it is in a fertilizer. Drufo in the environment is actually beneficial, and according to the defense's expert Skylar Weirs, Lush's use of Drufo in its fertilizer could actually help aid the current climate crisis. We, the defense, do not doubt that Dakota Weirs has suffered from non-Hodgkin's lymphoma and that this disease has led to many tragedies in her life. But Lush Fertilizer Incorporated is not to blame for those tragedies. Ladies and gentlemen of the jury, my name is Zahidi Balaji, and along with my co-counsel Frankie Kramer and Elizabeth Kugler, we represent Lush Fertilizer Incorporated. By the end of this trial, we hope you will side with the defense and agree that this whole case was done to protect an unsafe employee with an unconnected illness in order to make an unbelievable accusation on a company that provides so much aid to so many individuals. Thank you.
The prosecution may call their first witness, or plaintiff, sorry.
Thank you, Your Honor. At this time, the plaintiff would like to call Dakota Weirs to the stand. Ms. Weirs, can you please state and spell your last name for the court?
My name is Dakota Weirs, W-E-I-R-S.
Why are you here today, Ms. Weirs?
I'm suing Lush Fertilizer because their product made me sick.
And can you please elaborate on why you are suing Lush Fertilizer?
So I was recently diagnosed with non-Hodgkin lymphoma, which I believe is the sole cause of my use of Lush Fertilizer.
And what would you like to gain from this trial?
I just don't want other people to be hurt. Lush is dangerous, and I really would hate to see someone else that had to go through the same thing that I did.
What was your life like before you were diagnosed with cancer?
I loved going to school, I loved being with my friends, and I worked really hard to get good grades. I excelled at school in various extracurricular activities, which included working at a landscaping company and helping out at a homeless shelter, but I can barely help out at home anymore. And the worst part is that I can't play piano, which was the greatest joy in my life.
Why was the piano so important to you?
Well, when I was little, my grandfather used to play the piano to me all the time. And so as a kid, I was drawn to that music. When I was 7 years old, my grandfather actually passed away. And after that, I realized that the piano was the only way for me to ever be close to him again.
And where did playing the piano take you?
Well, after my grandfather passed, I started taking lessons all the time. And I loved it so much that I even ended up studying music theory in my free time. And soon people would come from all over the place to hear me play. And I was offered a number of scholarships.
Can you please tell us more about the scholarships you received?
I was actually...
Honor, relevance.
Response?
Your Honor, part of the plaintiff's job in this case is to show how the defense took away her life. Since we are not allowed to do economic damages, we are supposed to prove that the defendant took away her life.
Your Honor, may I respond?
Yes, you may.
Your Honor, in this case, we're not objecting to the relevance as to Ms. Weirs' damages in this case, but rather we'd like the discussion of said damages to be limited again to the economic or to the emotional and mental damages that she has suffered rather than the economic damages in this case.
I believe this goes towards non-economic damages overruled at this time. Please continue.
Thank you, Your Honor. What changed when you became sick?
I started to feel sick all the time, and I had severe pain because of my swollen lymph nodes and frequent chills, as well as chest pains. And I can't sit for long periods of time at the piano due to fatigue and my shortness of breath.
And did this change your future at all?
Yes, because I had to turn down my Juilliard scholarship because there's no way that I could complete such a rigorous program in the condition that I'm in.
Let's go back to when you said you had a job in high school. Where did you work?
I worked at Havens Landscaping.
And what did you use while you worked there?
We used Lush fertilizer.
Were you told to wear protective clothing while using the fertilizer?
I was, but nobody else did. I was 14, it was hot, and I really didn't want to feel suffocated in long coverings. If someone had told me that this fertilizer did in fact cause cancer, then of course I would have worn it, but nobody did.
And what led you to believe that Drufo made you sick?
I have a twin, Skylar, who's also testifying against me in the defense. And when I got sick, I realized that Skylar had never worked at the landscaping company. And since non-Hodgkin's lymphoma isn't genetic, it's based off of environment. The only environment that was different between me and Skylar was when I worked at the landscaping company. And it all clicked after I saw something on the news.
And what exactly did you see on the news?
On the news, I saw a story about Lush and its main ingredient, which was Drufo.
Response?
Your Honor, this is not being used for the truth of the matter asserted. I'm simply asking Ms. Weirs why she thought Drufo made her sick.
Any response?
Your Honor, I believe that this does go to the truth of the matter asserted, as if Ms. Weirs is going to be testifying directly to what the news story said, then that does go to the heart of what the news story is asserting, and as such, it cannot be entered into evidence.
I'm going to sustain the objection.
Okay. What did you do after you saw the news story?
I called my landscaping company that I had worked for to warn them because I thought it was strange that there was no warning on the label.
Ms. Weirs, do you have a clean, just wait a second. Sorry, we're going to bring up Exhibit 1.
You are muted, counsel.
Oh, thank you, Your Honor. Ms. Weirs, can you please identify Exhibit 1?
Yes, this is a label of Lush fertilizer that my company had given me.
And you can confirm that this is the exact label that you received from your boss?
Yes, it is.
Your Honor, at this time, I move for the admission of Exhibit 1 into evidence.
Any objection?
No objections, Your Honor.
So admitted.
Ms. Weirs, did you see this label while you worked at Lush Fertilizer?
Yes, I did.
What is the first active ingredient listed?
The first active ingredient is Drufo.
And what does the safety recommendation say?
It says that users should wash hands before and after use of this product.
And was this consistent with other fertilizer labels?
It was.
Did anything surprise you about this label?
It surprised me that there wasn't a warning about it potentially being carcinogenic on it, because Lush should have assumed that people wouldn't read through the entire safety recommendations and assume that people would be wearing short sleeves during the summer.
Is there anything else that you found out about Drufo?
Well, we looked into Lush that was being sold in other companies, specifically, or in other countries, specifically France, because my father speaks fluent French. And we found out that Drufo is not actually allowed in other fertilizers in other countries.
Thank you, Your Honor. No further questions at this time.
Any cross-examination?
Yes, Your Honor.
You may begin.
Good afternoon, Ms. Weirs.
Good afternoon.
Before we begin, I'd like to offer you my sympathies. I understand that cancer is a terrible thing, and we all hope that your fight is a successful one.
Thank you.
I'd like to begin by asking you a few questions about your employment at Haven Landscaping. You worked for Haven Landscaping since you were 14, correct?
Yes, that's correct.
And your primary job was to spread seed and fertilizer?
That is correct.
I'd like to direct your attention to Exhibit 1, which has been previously admitted. My co-counsel should be sharing that briefly. Now, Ms. Weirs, you claimed in your witness statement that the label on Lush fertilizer had no warnings.
I did.
However, on the right section of the label, the word hazards is written in all capital letters.
Yes, I see that.
And directly beneath it, it reads, "Caution, avoid contact with eyes or clothing."
Yes, it does say that.
And beneath that instruction, the label recommends that you, the user, wear protective clothing to cover any exposed skin.
That's correct, but I was 14, it was hot, and no one else was wearing protective clothing either.
Ms. Weirs, that wasn't quite my question. My question was whether the label recommended that you do this.
It does.
And this label also instructs you to wear a respirator or an N95 mask while maintaining proper PPE.
Yes, that's correct.
But you didn't wear those items, did you?
I didn't, and nobody else did either.
In addition, your boss always instructed you to cover your face when working with any of the chemicals at Haven Landscaping?
That's correct, but it was never completely enforced.
But you were instructed to do so?
Yes, but it wasn't
Your
enforced.
Honor, this is asked and answered.
Response.
I'll move on, Your Honor. Despite the employee guidelines, you didn't wear long sleeves?
Nobody.
Your Honor, this is also asked and answered. Opposing counsel has already established that Ms. Weirs did not wear any protective coverings.
I'll allow it.
Would you like me to re-ask the question?
Yes, please.
Despite the employee guidelines, you didn't wear long sleeves?
That's correct, but I wasn't alone in that. Nobody else did either.
You didn't wear long pants?
No,
You didn't wear gloves when working with any fertilizers?
I didn't, but again, it wasn't just me that didn't wear any of this.
Ms. Weirs, your lawyer will return for a redirect, and you can explain further then. Right now, I just need a simple yes or no answer. You worked with a whole variety of other fertilizers at Lush, didn't you?
Yes,
But we don't have the warning labels from those products here today, do we?
no,
And we don't know whether any of those chemicals list cancer as a possible danger from working without protective equipment.
no,
You claim that you have suffered from the symptoms of non-Hodgkin's lymphoma in a permanent way,
yes, that's correct.
but your medical staff have not given up hope that you could be cured entirely from this terrible disease.
That's true. Everyone has hope, but it might not necessarily end out that way.
So you could still be cured entirely, isn't that right, Ms. Weirs?
That's correct.
Thank you, Your Honor. No further questions.
Does the plaintiff have any redirect on this?
Not at this time, Your Honor.
Thank you. In that case, the witness may be excused. Does the plaintiff wish to call any other witnesses?
The plaintiff calls Carson Durst to the stand. Will you please state and spell your name for the court?
Carson Durst, D-U-R-S-T.
And where did you get your education?
I received a bachelor's in chemical engineering from Arizona State University.
Where are you currently employed?
I work at Terrace Greenery.
And what is your current position?
I'm the lead production developer.
And what does a lead production developer entail?
Well, I oversee the development of our fertilizers and other lawn enhancement products.
And where did you work before Terrace Greenery?
Before Terrace Greenery, I worked at Lush Fertilizer.
When did you begin working for Lush?
I began working for Lush in 2003 as an intern, and within a few months, I had risen to a full-time position. Someone chalked this up to my relationship with the Don courts, but I was performing at a higher level.
And what do Lush and Terrace Greenery both have in common?
They're competitors in the production of fertilizer.
What was your biggest assignment you got while employed at Lush?
I worked on Drufo, a chemical patented bonding agent that helps keep their fertilizers preserved and intact. The chemical formula for Drufo was developed over a few years, starting in 2001. When I joined in 2003, they were in the process of testing the safety of the bonding agent.
Could you please shift your attention to Exhibit 4? My apologies, Your Honor. Okay. Do you recognize this exhibit?
I do. It's an email from Jerry Langley.
And who is Jerry Langley?
Jerry Langley was the product manager, so she saw my work with Drufo. Oversaw.
Is this email a method of communication regularly used by Lush Fertilizer?
It is.
And is this document a fair and accurate representation of the email that you originally received?
It is.
Your Honor, I offer to admit Exhibit 4 into evidence.
Response?
Yes, Your Honor. The defense has multiple objections to this document. Would you like us to address all those objections at once, or would you like us to address them one at a time?
All at once, please.
All right. Our first objection is to hearsay. And then our next objection is the best evidence rule. And finally, this witness has signed a non-disclosure agreement with Lush, the contents of which are in Exhibit 5.
Response?
Yes, Your Honor. Pursuant to Rule 807, residual exception, it is more probative on the point for which it is offered than any other evidence that has been proponent can attain through reasonable efforts.
Okay, that addresses one of the objections. What about the rest?
This is addressing Exhibit 4. I do not believe that it is pertinent to Exhibit 5. And what was the other objection?
There was a hearsay objection at first, then
Yes.
a best evidence, which you just addressed. With respect to the hearsay objection, any response?
Yes, the hearsay objection was the pursuant to Rule 807 residual exception, more probative on the point for which it is offered than any other evidence that the proponent can attain through reasonable efforts.
Okay, and with respect to the non-disclosure agreement blocking the admission of this exhibit?
This does not have to do with the non-disclosure agreement, Your Honor, because this is Exhibit 4, which refers to an email while at Lush, and it has nothing to do with the non-disclosure agreement.
Any response?
Yes, Your Honor. I don't believe co-counsel addressed the hearsay objection, but I could be wrong.
She did actually address it with the Rule 807, which is a hearsay exception.
Okay, Your Honor. In that case, we stick by our original statements or our original objections.
I will overrule the objections and admit the Exhibit 4.
Based on your familiarity with this email, can you describe its contents in general terms?
In regards to the Drufo study,
And what's the date on the email, Exhibit 4?
September 18th, 2003.
And what does this email say regarding the results of the Drufo study?
It says that there were concerns about the possibly carcinogenic nature of the Drufo.
Okay. And And what else is mentioned in this email?
It also mentions, could you repeat the question?
Yes, what else is mentioned in this email pertaining to the company?
It mentioned that we would be conducting an upcoming study verification exercise.
Okay, and approximately how long had you worked at Lush when you had received this email?
This email was sent in September and I began working there June, so that'd be about 4 months.
When was Lush's analysis of Drufo completed?
December of 2003.
And what happened when this analysis was completed?
There was a meeting in a conference room to discuss our findings. One scientist in particular expressed concerns that Drufo might be carcinogenic and linked to non-Hodgkin's lymphoma, but one upper echelon manager told us that we should probably keep that to ourselves.
Objection, hearsay.
Response.
This is not being offered for the truth of the matter asserted, but rather to show that managers of Drufo were given notice of a possible concern.
Response.
Your Honor, I feel this, or the defense feels that this is being offered for the truth of the matter asserted, as the matter asserted is whether or not these meetings happened and whether or not the concerns were addressed properly, and this goes to that.
I do agree. Objection is sustained.
Did you ever receive a final report from the study of Drufo?
About a month after that meeting, a copy of the report hit my desk.
What was your reaction to the report?
I believe the report was misleading. It seemed to me, based off my participation in the research, that some of the data was left out.
Okay. And was there anything else about Drufo in the report?
The report recommended baking Drufo to eliminate any possibility that it might be carcinogenic.
And why do you think they did not bake Drufo?
Well, I believe it will be framed like them going above and beyond expectations. I believe it was just to protect their shiny.
Objection, speculation.
Response.
Opinion exception rule 701 that a lay witness may offer their opinion if rationally based upon the perception of the witness, Your Honor.
Any response?
Yes, Your Honor. While the first part of Mr. Durst's statement was completely based on his opinion, he said, I'm sure it would be phrased in a way that would protect Lush's image or something along those lines, in which case that is not based on the witness's rational perception and is being offered as a fact, which is speculation.
I do agree. I think this exceeds the opinion testimony permitted by a lay witness. I will sustain the objection.
Why was Drufo important to the company?
Drufo was critical to the company's success, and it set them apart from other competitors.
After you received this report, what happened?
I started to receive some more pushback from senior members in my getting the more desirable assignments. It seemed to me that their performance reviews started to reflect their changed opinions.
Okay, and what happened next?
Well, I got another bad performance review in early 2005, so I went to Blake Doncourt to see if I could solve my problems with Jerry with him, but that conversation did not go as I had hoped.
I'm sorry, how so?
Well, he told me that I'd have to work on my problem. I'd have to work out my problems with Jerry on my own, and basically got no support.
So what did you do next?
Well, I could see the writing on the wall, and it became clear that I had no future at Lush. So I immediately started looking for a new job. That's how I got my job at Terrace Greenery, though not without interference from Lush.
What kind of interference from Lush?
Well, they actually took me to court to try and prevent me from working at Terrace Greenery. It was resolved, though, by me not working there for a period of 6 months.
So why are you testifying against Lush today?
Well, I suspect the defense will say I do it out of their grudge for them. I am doing it because it is the right
Objection,
thing to do.
speculation.
Response.
This is simply asking for the intentions of the witness in their presence in court today.
I will sustain the objection with respect to why he thinks the other party is expecting him to do that. Please rephrase your answer.
Would you like me to restate the question?
I would.
So why are you here testifying against Lush today?
I'm here because it's the right thing to do, and I just don't like the way Lush handled the study of Drufo.
Thank you, Your Honor. No further questions at this time.
In cross-examination?
Yes, Your Honor.
Please proceed.
Thank you, Your Honor. Good afternoon, Mr. Durst.
Good afternoon.
I want to start by focusing on the time you spent at Lush and your relationship with the CEO of Lush, Blake Doncourt. In just 3 months at your time at Lush, you were promoted to a full-time position, correct?
Correct.
And you said that this was because you were performing at a higher level and that it had nothing to do with your relationship with the Doncourts?
I said that I was performing at a higher level, and regardless of my relationship with the Doncourts, I was qualified.
So that's a yes to my question. You were performing at a higher level and that's why you were promoted, right? Not because of your relationship?
I was performing at a higher level, but it was partially based off my relationship with the Doncourts.
So it's your testimony today that it was partially based on your relationship with the Doncourts?
While they did pull strings for me, I again was performing at a high level and was fully qualified.
Oh, I apologize, Mr. Doncourt. So you admit that Blake pulled strings to you to get for you to get hired in the company?
Yes.
And later, Blake even admitted that he overlooked more qualified applicants to hire you, correct?
That is correct.
Now, there were mounting complaints from your coworkers about your job performance.
Correct.
So much so that the executive team made you sign a performance improvement plan?
They did, yes.
And you complained to Blake about this performance improvement plan, correct?
Yes.
And you were upset when Blake took Jerry Langley's side over yours?
Yes.
Now, I'd like to talk about, my apologies, I'd like to talk about your position at the company and whether it provided you with a big picture of the research into Drufo. You were hired in 2003 to work with the research and development team at Lush, correct?
Correct.
But Lush had been working on the development of Drufo for 2 years prior to your arrival, correct?
Correct.
And so you don't really know about any research the company did with Drufo or findings the company made during those years you weren't there?
Correct. But when I was there, they were testing the safety, so I can attain to that.
But you don't know what they did for the previous 2 years, correct?
Well, I know they, no, correct.
You even admit that most of what went up the flagpole regarding Drufo was above your pay grade as an intern, correct?
Correct.
And so for the first 3 months that you worked with Lush, you can only speculate on higher level research done on Drufo?
Correct.
Finally, I want to talk about your relationship with the company after you left, your new job at Terra Greenery, and the supposed email you claim came from Lush regarding Drufo. Terra Greenery is Lush's biggest competitor, correct?
Correct.
And you applied to Terra Greenery after you felt that Blake had betrayed your relationship?
Well, since it was fertilizer, it only made sense.
I'm sorry, what was that objection?
Objection relevance, Your Honor.
Response?
Your Honor, this goes to the relationships in this case, as Blake Doncourt is a main witness in this case, and this goes to potential biases that this witness might have against that witness.
Overruled. Please continue.
Would you like me to re-ask the question, Mr. Durst?
Yes, please.
And you applied to Terra Greenery after you felt that Blake had betrayed your relationship?
Correct.
So you started working with Terra to get back at Blake?
Could you rephrase the question?
Would you like me to re-ask it?
Yes, please.
So you started working with Terra to get back at Blake?
Objection argumentative, Your Honor.
I'll
response?
rephrase, Your Honor.
Okay.
So one of the reasons that you started working for Terra Greenery was because you wanted to I apologize. So one of the reasons that you started working at Terra Greenery was because the relationship with Blake didn't work out at your previous job?
Well, I left Lush because my relationship with Blake didn't work out, but I joined Terrace Greenery just because it was a fertilizer company and I needed a job.
So you left Lush and started working for Terra Greenery, correct?
I did.
Now, you signed a confidentiality agreement when you first started working with Lush, correct?
Correct.
And that agreement barred you from disclosing Lush's trade secrets to any third party?
Correct.
However, you now say that the product you are working on with Terra could outperform Lush's.
Correct.
The agreement also bars you from working with a competitor of Lush for up to 2 years.
Well, we decided that I would not work at Terrace Greenery for a period of 6 months, but correct.
Of course, yeah. However, you found Terra and applied while you were still working for Lush.
Correct.
So that promise you made to Lush to not work for another company was a lie?
Correct.
Now, while you still worked for Lush, you claim to have received an email about research dealing with possible carcinogens in Drufo, correct?
Correct.
And in this alleged email, it was made clear that concerns or questions could be talked about with Jerry Langley over email, correct?
Correct.
But we don't have any emails from you about your concerns with Drufo?
Well, my findings were written in my notebook, which was reviewed by Jerry Langley. So I guess you could say she understood what I was seeing.
But we have no emails or evidence that that happened.
No
other than
emails.
Thank you, Your Honor. I have no further questions at this time.
Is there any redirect?
Yes, Your Honor, briefly. Carson Durst, why did you develop this product at Terrace?
Well, I'm developing this product at Terrace because it's my job. I mean, I'm the product developer, so it only makes sense that I would be doing my job.
Thank you, Your Honor. No further questions.
Thank you. The witness may be excused. Do the plaintiffs wish to call another witness?
Yes, Your Honor. Apologize. Yes, Your Honor. The plaintiff calls Dr. Casey Rogers to the stand.
You may proceed.
Doctor, could you please state and spell your last name for the court?
My name is Dr. Casey Rogers, Rogers.
And Dr.
Your
Rogers,
Honor, before we proceed, our attorney that is crossing this witness, her audio is not working. Can we be given a second to figure out that situation?
By all means.
Your Honor, may we ask to pause time during this?
Yes, this is a technical difficulty. Please pause time.
Thank you.
All right, thank you, Your Honor. Your Honor, we're ready to proceed.
Very well.
Thank you. Doctor, could you please state and spell your last name for the court?
My name is Dr. Casey Rogers, Rogers.
And Dr. Rogers, what do you do for a living?
Currently, I'm a professor in the Horticulture and Entomology Department at the University of California, Berkeley.
And doctor, what education have you received?
I received my Bachelor of Science degree in Agriculture and Chemistry from Colorado State University. Then I went on to get my PhD in Agriculture and Entomology from the University of California, Berkeley.
And doctor, do you have any prior work experience in this field?
I do. Prior to earning my PhD, I worked as a research analyst for a large multinational chemical company.
And doctor, what does a research analyst's job entail?
I worked with clients in the chemical industry as a consultant working to solve their specific business problems. That involved collecting, summarizing, synthesizing, and analyzing the information I received.
And doctor, have you researched or written any sort of articles of your own in these areas?
Of course, I've been studying the effects of prolonged exposure to chemicals on the body for years. I've also published numerous scholarly articles and researched DRUFO before, along with other herbicides. Most of my research has been focused on the harmful effects of chemicals, including DRUFO, on the human body.
Your Honor, the plaintiff offers Dr. Casey Rogers as an expert in the fields of agriculture, horticulture, and chemical effects on the human body pursuant to Rule 702.
Any objection?
Of voir dire, Your Honor.
By all means, please.
Good afternoon, Dr. Rogers.
Good
I'd
afternoon.
like to begin by discussing your education. Pesticide chemistry and toxicology are research interests of yours. Is that right?
Yes,
But you don't hold any degrees in those areas, do you?
no, I do not.
You also don't possess any degrees or formal training in medicine.
No, not formally, no.
More specifically, you don't hold a degree in oncology, the study of cancer.
I do not know.
Thank you. Your Honor, the defense does not object to Dr. Rogers being admitted as an expert in agriculture and toxicology. However, we do object to the witness testifying about cancer, specifically non-Hodgkin's lymphoma, due to the fact that they lack knowledge, skill, training, and objection required to testify as an expert in these areas under Rule 702.
Any response?
Your Honor, Dr. Casey Rogers will not be testifying specifically about cancer, but he has a Bachelor of Science degree, as well as entomology and horticulture. So he is very well versed in terms of chemical effects on the human body. Cancer is one of those effects, but he will not be talking about any sort of the specific science behind cancer or non-Hodgkin lymphoma.
May I respond?
Please.
We also want to clarify that we do not, as a defense, we do not think that Dr. Rogers is qualified to be testifying about Miss Weirs' illness and how it relates to her body, considering that he is not Miss Weirs' doctor.
At this time, I'm going to admit the witness as an expert, but not allow any testimony with respect to specific cancers. Simply saying cancer in general may be one thing, but not to go into the medical testimony regarding specific cancers.
Thank you, Your Honor.
Thank you. Doctor, are you well versed with Lush's products?
Yes, I have personally analyzed the complete chemical makeup of each and every Lush product.
And how would you do this?
I used a mass spectrometer. I measured the mass to charge ratio of ions, and the results were presented as a mass spectrum, a sort of plot of intensity as a function of the mass to charge ratio.
And Dr. Rogers, have you heard of DRUFO before?
Of course I have. I've been researching the negative effects of DRUFO for years. It first caught my attention when it was introduced to the market, and since then, I have been researching DRUFO on my own and made recommendations to regulatory agencies who's asked for my expertise. My research on the chemical has also been used in litigation before.
And doctor, could you please explain what DRUFO is?
DRUFO is a patented product that Lush uses in all of their products as a bonding agent. It is used in their fertilizers to keep the fertilizer preserved and intact.
And doctor, when you first heard about it, what were your first thoughts of this chemical?
As I mentioned before, I heard about Drufo right when it was introduced to the market. I'd always been worried about its effects from the moment I learned what it really was. And just to prove my suspicions, I began reading reports from my colleagues regarding the many negative effects associated with Drufo.
And doctor, how did you react to these findings?
I decided it was best to conduct my own study on the chemical. My goal was to find out if there were any adverse health effects in persons who were exposed to Drufo.
And doctor, how did you go about conducting this study?
I studied 3 groups of people. My main focus was on those who used Drufo as a part of their job. So of course, I studied farmers. I also concluded a control group of people, like any good study should. This included groups of people who had never been exposed to Drufo before. The final category entailed individuals who were exposed to Drufo occasionally, as I wanted to see if the amount of exposure was in direct correlation to any adverse health effects. These groups were monitored for a period of years following their exposure, and each group was monitored for health conditions, and the results collected from the exposed patients were then compared to those in the control group.
And doctor, what were the results of this study?
The data showed an increase in diagnoses of serious health conditions regarding those who were exposed to Drufo.
And what were these diagnoses?
My study showed that individuals who were exposed to Drufo have higher incidences of cancer, including non-Hodgkin lymphoma.
Objection outside the scope of the witness's expertise.
Response.
Sorry. Your Honor, Dr. Casey Rogers is only speaking of the results of his study, one of these results being development of non-Hodgkin lymphoma, but no science of this development has been entered.
Response.
I stand by my objection, Your Honor.
Earlier, I did make a ruling that the witness was not going to be able to talk about specific types of cancer. I will stand by that ruling earlier, so that objection is sustained.
Doctor, could you please explain? I apologize. So how does something like cancer affect somebody's life?
This cancer specifically is going to affect her life.
Objection outside the scope of the witness's expertise.
Response.
Your Honor, as you said earlier, Dr. Casey Rogers is allowed to talk about cancer as a whole, but not specific types of cancer. I'm not asking about non-Hodgkin lymphoma or a specific type. I'm saying any sort of cancer.
At this point, the witness is exceeding his qualifications as an expert. He is not an oncologist. Talking about the effects of cancer on a human is not within the scope of the expert's testimony.
Okay, thank you. I'll move on. So doctor, just to finish, what conclusions did you take from your study?
Because of this study, we note that there is a high degree of medical probability that Ms. Weir's non-Hodgkin lymphoma was caused by prolonged exposure to Drufo.
Objection outside the scope of the witness's expertise.
Response.
Your Honor, Dr. Casey is just stating the results of his study.
I'm going to overrule the objection at this time and allow the expert to answer.
Should I re-ask my question?
It's up to you, counsel.
Doctor?
I can continue.
Okay, thank you.
Like I said, there is a high degree of probability that Ms. Weir's non-Hodgkin lymphoma was caused by prolonged exposure to Drufo.
Thank you. No further questions.
Any cross-examination?
Yes, Your Honor. Dr. Rogers, I want to focus on your purported study of Drufo. Oh, yes, sorry. This is where I should be. In your study, you observed the effects of Drufo on farm laborers and gardeners, yes?
That is correct.
And you claim that people were more likely to be diagnosed with cancer because they used Drufo.
Yes, that is correct. That is what the results showed of my study.
However, people in agricultural professions are exposed to lots of chemicals and hazardous materials.
That is true.
So it's possible that these people developed cancer from other hazardous materials they worked with.
Objection, Your Honor.
What's the objection?
This question is asking the witness to testify outside of his expertise.
Response?
Your Honor, I'm simply asking cancer using cancer as a broad term, which was declared that the expert may testify to.
May I respond?
Briefly.
Your Honor, she is asking about the science of the development of cancer, which Dr. Casey Rogers is not an expert in.
At this time, I'm going to overrule the objection. You've opened the door to this by asking the expert about his study, and this is asking about the basis of his study and the evidence that was brought in to form his opinions. So that objection is overruled. Please continue.
Would you like me to repeat the question?
Yes, please.
So it's possible that these people developed cancer from other hazardous materials they've worked with.
I think it is possible, yes.
And this study you've conducted has not been peer-reviewed or replicated, has it?
I do not control what other scientists choose to peer review or replicate, but no, it is not.
Thank you. Doctor, you claim that Drufo causes cancer, and while Lush obviously disputes that and will provide its own expert to refute your findings, I want to imagine for a second that you are somehow correct. You recommend that anyone working with Drufo should wear long sleeves and pants?
I think they should, yes.
And that they should wear a medical grade protective mask?
Correct.
And you made these recommendations because you viewed them as a way to protect workers from harmful chemicals?
Yes, of course. We try to protect all of our customers.
But Dakota Weirs has already testified to ignoring these recommendations and working without protective clothing or equipment.
As far as I know, yes. She was 14, though.
And Dakota Weirs has also testified to working with lots of different products and chemicals.
Objection, Your Honor. These questions are asking Dr. Casey Rogers to testify outside of his witness statement.
Response?
Your Honor, Dr. Casey Rogers was present for Mrs. Weir's testimony today, so he should be able to testify to what she said in those statements today.
Response?
Your Honor, these things have already been stated by this witness and Dr. Casey Rogers.
I'm going to overrule the objection, but please get to the point.
Yes, Your Honor. And one of these other products or chemicals could be responsible for Dakota's cancer.
There is that possibility, yes.
Thank you. Now, I'd like to talk about your financial compensation in this case. You're being paid to testify here today?
That is correct, I am.
And if you win this case, you will benefit from future lawsuits you'll testify in?
I would think so. However, I cannot guarantee that.
But to be clear, you stated that if you win this case, it will open the door to class action lawsuits and you will be at the forefront of that battle?
I would like to be at the forefront of that battle, yes.
Thank you, Your Honor. I have no further questions.
Can you redirect?
A brief redirect, Your Honor.
Please continue.
Doctor, is it possible, in any way possible, for you to guarantee that people use any sort of protective clothing that you suggested?
I cannot guarantee that, no.
Thank you. No further questions, Your Honor.
The witness may be excused. Does the plaintiff wish to call any additional witnesses?
No, Your Honor, the plaintiff rests.
Very well. Are there any motions that needed to be addressed before the defense's case in chief?
Yes, Your Honor. My audio is not working. May I please have a moment to quickly figure this situation out?
Certainly.
Thank you, Your Honor. Your Honor. Your Honor, the defense is ready to proceed.
Okay, please go.
We would like to call Mr. Blake Doncourt to the stand.
You may begin.
Good afternoon, Mr. Doncourt.
Good afternoon.
Please state your name and spell it for the court.
My name is Blake Doncourt, and that's spelled Doncourt.
Thank you. I want to begin by talking about your career and your company, Lush Fertilizer Incorporated. What position do you hold at Lush Fertilizer?
I'm the Chief Executive Officer or CEO of Lush Fertilizer.
And how long have you been working at the company?
I've been working at Lush since I founded it in 2000.
And could you tell us a little about Lush Fertilizer Incorporated?
Absolutely. So when I first started Lush, it was a small unknown producer of fertilizers, and I've since grown it to be one of the foremost producers of fertilizers in the world. Now our product, Lush Fertilizer, is used by governments, individuals, and businesses to produce vibrant green grass. I have worked night and day to make the company the profitable company that it is today, and me and our team have put countless hours of research into our products.
And how has Lush's success helped you give back to society?
Giving back to society is actually very important to me, and Lush's success has allowed me to direct 10% of our profits to various charities. And these charities work to clean up the most polluted areas of the world's oceans, educate the public on environmental issues, and importantly, decrease the global nitrogen footprint. Pertaining to these charities, I was nominated for the Champion of the Earth Award in 2020, and I had hoped to win it.
And moving on, I want to talk about the Lush fertilizer product and the chemical known as Drufo. What is Drufo?
Drufo is a bonding agent that we use in our flagship product, Lush Fertilizer.
And why is Drufo coming into question today?
Dakota Weirs and Casey Rogers are asserting that Drufo is somehow carcinogenic and causes non-Hodgkin's lymphoma.
And do you believe that their assertions are correct?
Absolutely not. Before we ever put Lush on the market, our toxicology research team looked extensively into whether or not it was harmful, and we found that it was not.
Thank you. Now, I want to address the argument about warning labels on Lush fertilizer. What factors did you consider in putting a warning label on your product?
The number one factor that we took into consideration before putting a warning label on our product was consumer safety. Before we ever put our product on the market, we ran tests to determine that if it was toxic or carcinogenic, and we found that our product was not carcinogenic beyond what you'd expect with any fertilizer. It wasn't toxic in any way, so we were not required to put a warning label on it under any federal or state laws.
And was there any evidence linking Lush fertilizer to cancer?
Absolutely not. In fact, like I said before, we ran trials on Lush, on our product before we put it on the market, and we found that there was no evidence linking it to cancer. I would never put a carcinogenic product on the market.
Thank you. Now, I want to address the claims that Carson Durst has made regarding Lush Fertilizer Incorporated. When did you become aware of Carson's claims about Drufo?
I didn't become aware of these claims until after Carson had already been fired from Lush Fertilizer and had begun working for our competitor, Terra Greenery.
And were there any opportunities given to Carson to provide you or your company with his claims?
Oh, absolutely. With Carson's job, he would have had every opportunity to inform me or the team if he had any concerns, but we never heard anything.
And were you provided with any evidence related to Carson's claims?
Again, no, there wasn't any evidence provided at all. In fact, many of Carson's claims would have left a paper trail in our system, but we turned over our email system to the plaintiff's lawyers, and their search of it found no evidence for these claims.
And how would you like to respond to Carson's email that he claims is relevant?
This email is completely manufactured. Like I said before, we turned over our email system to the plaintiff's lawyers, and their search of it found nothing.
And what else has Carson claimed to be true?
Carson also claimed that we crafted our development reports in such a way to leave out negative details about Drufo, but that's not how we craft our development reports at Lush. We make honest development reports.
And does anybody else have these concerns to your knowledge?
No one else has ever had any concerns about our development reports being dishonest.
And what do you make of Carson working for Terra Greenery?
I mean, I'm hurt that Carson would take the
Speculation, Your Honor. Objection.
Response?
Yes, Your Honor. This is rational perception, as my client has worked with Carson and has gained knowledge about Carson as a person and who he is, and therefore is able to rationally perceive as to a situation that concerns both his company and a former employee of his.
Rational perception does not extend to statements. That objection is sustained.
And how would Carson working for Terra Greenery pose a threat to your company in any way?
I didn't think that Carson working with Terra Greenery could pose a threat to my company since he had signed a non-compete agreement with Lush.
Your Honor, I will be constructively sharing Exhibit 5 to the witness and to Your Honor. Do you recognize this?
Yes, this is the agreement that I signed with Carson Durst when they were hired at the company.
And is this a fair and accurate copy of this document?
Yes, it is.
Your Honor, at this time, I move for the admission of Exhibit 5 as evidence.
Any objection?
Lack of foundation, Your Honor.
Response?
Your Honor, I believe we've laid the proper foundation, as Mr. Doncourt has just said that he didn't think that Carson would be able to give trade secrets because of this non-disclosure agreement. And now I am admitting the non-disclosure agreement to ask questions about what exactly that entails.
The objection is sustained. Please lay additional foundation.
So what does this non-disclosure agreement entail?
This non-disclosure agreement specifies that Carson Durst, the employee, can't disclose any trade secrets or about how we produce our product or run our company to any third party. I have all my employees sign a similar agreement when I hire them.
And how often would you say that your employees, or you make employees sign this document?
I make every employee that I hire sign a non-compete agreement.
Your Honor, at this time, I move to admit Exhibit 5 as evidence.
Any objection?
No objection, Your Honor.
Okay, Exhibit 5 is admitted.
What specifically does the non-disclosure covenant say?
The non-disclosure covenant specifies that the employee, in this case Carson Durst, will not disclose any trade secrets from Lush to any third party.
And how, if at all, do you feel that Carson has violated this agreement?
Well, I do absolutely believe that Carson has violated this agreement. For starters, as part of his testimony today, he has spoken about how we produce our product and run our company. And additionally, Terra Greenery is about to release a product similar to ours, which I believe to be hardly a coincidence.
Thank you. Finally, I would like to address the claim about you baking your products and the decisions that go into doing so. What does baking a product do to it?
So baking a product is a process that can remove any potential carcinogens from that product.
And was it necessary?
This is beyond the scope of the witness, Your Honor.
Response?
Your Honor, this is the witness's product, as he is the CEO of this company, and therefore he would know exactly what it is that exactly what was needed for his product, and different processes that he could do to his product. Additionally, this witness has also made a spreadsheet, so he was fully aware that this product could be baked.
Response, Your Honor.
What's your response?
The witness is testifying to the exact science of not baking the Drufo, and they have not been admitted as an expert witnesses in this field.
May I respond, Your Honor?
Very briefly.
They are not testifying to the specific sciences of this. They are simply just saying what baking a product can do to it, and that would be something that this witness knows, as they are the CEO of this company and manufactured this product.
The objection is overruled at this time, but I think that we're reaching the limits of where the witness can speak without being endorsed as an expert.
Thank you, Your Honor. Would you like me to re-ask the question, Mr.
Yes,
Doncourt?
please.
What does baking a product do to it?
Baking a product is a process that can remove any potential carcinogens.
And was it necessary to bake your product?
Oh, absolutely not. Like I said before we ever put the product on the market, our research and toxicology team looked significantly into whether or not it was carcinogenic and into its various toxicities, potential toxicities. And what we found is that there was no risk of carcinogens whatsoever. So it was not necessary to bake the product.
And was cost a factor in this?
Well, yes, of course, cost was a factor because I do run a company. But I would say that, of course, the number one factor was consumer safety.
Thank you. Your Honor, I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Good afternoon, Mr. Doncourt.
Good afternoon.
Lush's fertilizer contains Drufo, correct?
Yes, that's right.
And baking the Drufo would have removed any risk of the fertilizer being possibly carcinogenic, correct?
Well, I don't believe that there was any risk of the fertilizer being carcinogenic at all to begin with.
But baking it would have removed any risk if it was a possibility, correct?
Well, yes, I suppose so.
And Lush decided not to bake their Drufo, correct?
We came to that decision because we had already tested the product before we put it on the market and determined that it was not carcinogenic.
By not baking the Drufo, you found that Lush would increase its profits by 6% in the first year, correct?
Yes, that's correct.
Objection, assuming facts not in evidence.
I'm sorry, could you clarify your objection slightly? Which fact is not evidence?
That Mr. Doncourt would increase his profits by 6% within the first year. And I'm assuming that counsel is referring to the spreadsheet, which has not been admitted as evidence.
Response?
This is in the witness statement, Your Honor.
I'm going to overrule the objection, even though the exhibit hasn't been admitted. You can still certainly be asked the question.
By not baking the Drufo, you found that Lush would increase its profits by 6% in the first year, correct?
Well, I mean, I put a lot of thought into the decision to not bake Drufo, and like I said before, the primary thing that we considered was consumer safety, but that is correct, yes.
And yes or no will suffice on the next one, Mr. Doncourt. And by not baking Drufo, Lush would also increase its profits by 2% every additional year after that initial year, correct?
Yes, that's right.
Moving on, your fertilizer is sold in bags, and those bags display a safety recommendation, correct?
That's right.
Please shift your attention to Exhibit 1 as it has already been admitted into evidence.
All right.
One moment, please. They're about to screen share. Mr. Doncourt, do you recognize this exhibit?
Yes, I do.
What is this?
This is the safety recommendation that we put on our product.
And does the label recommend protective covering?
Yes, it does.
And it says to wear protective covering because the fertilizer is not safe, correct?
Well, yeah, in fact, all fertilizers are made of chemicals, so no fertilizer would be safe to put on your bare skin. You're always going to want to wear a protective covering when working with chemicals. So of course, we put those recommendations to ensure the safety of our consumers.
So that is a yes, that you put those protective coverings on because the fertilizer is not safe?
Yeah, like any chemical, it's toxic. However, it is not carcinogenic.
Okay, thank you. And most people use fertilizer in the summer, correct?
I believe fertilizer is used all year round, but certainly in the summer, yes.
And it gets pretty hot in the summer, correct?
It depends on where you live, I suppose, but yes.
And most people do not wear long clothing in the summer, correct?
Well, I mean, of course, if you're working with a fertilizer, you have to wear long clothing to ensure your safety, but I mean, yeah.
I want to talk to you about what Lush knew about Drufo. Carson Durst worked at Lush as a product development engineer, correct?
That's right.
And you claimed the existence of Jerry Langley's email warning about the dangers of Drufo is all a lie, correct?
Yeah, that's right. That email doesn't exist in our email system, which we did turn over to the plaintiff's lawyers.
However, if you had seen that email, you would have been put on notice for dangers associated with Drufo, correct?
Sorry, could you re-ask the question? I didn't catch that.
Yes, sir. However, if you had seen the email, you would have been put on notice for dangers associated with Drufo, correct?
Well, if that email existed and there were dangers with Drufo, then yes, I would have seen it and known about them, but it doesn't, so.
But you cannot guarantee that this email has not been deleted from Lush records, correct?
Well, I'm saying that the email has not been, yes, I can guarantee that it hasn't been deleted from Lush records. We have not deleted it and we've turned over our accurate records.
And you have stated that the environment is one of Lush's #1 priorities, correct?
That's right.
Should your product cause cancer, that would ruin your reputation as a company, correct?
Should my product cause cancer, that would be terrible, but I would never put a product that causes cancer on the market. Our product does not cause cancer.
And in the case that it did, it would ruin your reputation of the company and it would affect your business, correct?
Well, I believe if our product caused cancer, the reputation of my company would be the last thing I'm worried about.
Okay. Thank you, Your Honor. No further questions.
All right. Is there any redirect?
No redirect at this time, Your Honor.
The witness may be excused. Does the defense wish to call any additional witnesses?
Yes, Your Honor. The defense calls Dr. Devin Williams to the stand, please.
You may begin.
Good afternoon. Please state your name and spell it for the court.
Good afternoon. My name is Dr. Devin Williams, spelled DEVIN WILLIAMS.
I'd like to begin by talking about your educational background. Where did you begin your education?
I received a Bachelor's of Science in Toxicology from the University of Utah in 1993.
And where did you continue that education?
I went to Colorado State University, where I earned a master's degree in forensic toxicology in 1998. I then went on to earn a PhD in toxicology and pharmacology from CSU in 2003.
Do you have any certifications in these fields?
I'm certified in clinical and forensic toxicology in Colorado, New Mexico, Wyoming, and Utah.
Now, I would like to discuss your experience in these areas. Can you explain some of your past roles as a forensic toxicologist?
After receiving my bachelor's, I worked as the chief medical examiner toxicologist at the Larimer County office in Fort Collins for 2 years.
And what did this role entail?
I analyzed human samples collected from autopsies to determine the role of drugs and other toxic chemicals in causing death.
Do you have any other relevant experience in forensic toxicology?
I taught as the assistant professor of toxicology and pathophysiology at CU for 7 years.
Do you have any other teaching experience?
I currently teach toxicology at CSU and forensic toxicology at the University of New Mexico.
Your Honor, based on Dr. Williams' education, experience, and knowledge, we would like to admit the witness as an expert in forensic toxicology with a specialty in toxicology of environmental and occupational chemicals.
Any objection?
No, Your Honor.
The witness is so admitted.
I would now like to discuss your current position. What is your current position at Lush Fertilizer?
I'm in charge of the toxicology research and development labs at Lush, as well as the company's ethics committee.
And how long have you served in this position?
For 12 years.
Can you explain to the court what you do at Lush?
I lead the labs at Lush and oversee work concerning our fertilizer's environmental impact. My role is to maintain Drufo's major benefits while keeping our customers safe.
I would now like to discuss Lush Fertilizer's use of the chemical Drufo. Dr. Williams, can you explain to the court what Drufo is and how it works?
In order to understand how Drufo works, I must first begin with how fertilizers work. So fertilizers enhance plant growth in 2 ways, either by adding nutrients or by increasing the effectiveness of the soil. The problem with this is it creates an issue known as eutrophication.
What is eutrophication?
Eutrophication is the buildup of nitrates in bodies of water. When fertilizer is sprayed, excess nitrogen in that fertilizer is converted into nitrates, and those nitrates are then carried into streams and lakes.
And what is the danger of the eutrophication process?
When those nitrates accumulate in bodies of water, they create algae blooms that harbor bacteria that can be harmful for humans. Luckily, Lush created Drufo as a way to prevent eutrophication from happening.
How does Drufo prevent algae blooms and toxic bacteria?
Drufo uses a binding agent so that less fertilizer needs to be sprayed in order to achieve the same result. Less fertilizer means less nitrogen, less nitrates, less eutrophication, and ultimately less danger for humans.
Thank you. Now, I'd like to address the use of Drufo on a global scale. Have there been any complications with Drufo's use in other countries?
Unfortunately, yes.
Objection,
Currently,
Your Honor. That is the leading question.
I'm sorry. Your objection is just leading?
Leading question, yes.
Overruled. It's not a leading question. Please continue.
Dr. Williams, would you like me to repeat the question?
yes, please.
Have there been any complications with Drufo's use in other countries?
Unfortunately, yes. Currently, Drufo is banned in the European Union. However, that ban is not based on cancer concerns.
What are the EU's concerns surrounding Drufo?
The EU has a directive that prohibits the use of fertilizers that contain certain amounts of nitrogen. Although Lush's Drufo-based fertilizer greatly reduces nitrate output, it still contains nitrogen. And when the EU tested Drufo, they believed that it had more nitrogen than its directive allows, so they banned it.
And do you believe that was an accurate conclusion?
I do not. The EU tested Drufo under unrealistic laboratory conditions. If you put Drufo in a petri dish with just the right amount of bacteria, it'll produce just as many nitrates as any other fertilizer. However, what the EU's experiment failed to consider is how Drufo acts differently in nature.
And why is that significant?
Because nature is where Drufo is intended to be used. The whole reason we created Drufo was to prevent nitrate output that fertilizers put into the environment, but Drufo will only work when it is actively used in nature.
What was Lush's reaction to the EU's decision to ultimately ban Drufo?
Lush could have fought the EU decision, but at the time we were a brand new company with limited resources. We decided to focus our efforts into saving the planet as opposed to fighting pesky legal battles.
Does Lush intend to take any further action concerning Drufo's use in Europe?
Yes, in fact, my department is currently finishing a study that will prove that Drufo-based products lead to reduced eutrophication when used in real-world applications. We plan to submit those findings to the EU so that they will reconsider their misinformed ban.
I would like to turn our attention to the plaintiff's claim that Drufo is somehow related to non-Hodgkin's lymphoma. Doctor, in your professional opinion, is Drufo related to the cause of non-Hodgkin's lymphoma?
No, the use of Drufo has not been correlated with an increase in cases of non-Hodgkin's lymphoma. Notice I say it doesn't correlate with an increase in cases. I can't just say Drufo doesn't cause cancer because that isn't how science works.
Can you elaborate on that?
Well, if you take any group of people, a small number of them will develop non-Hodgkin's lymphoma. Regardless of whether those people are using Drufo or not, some of them will get cancer. However, we've concluded that using Drufo doesn't cause an increased likelihood of developing cancer.
And what information did you gather to come to this conclusion?
We use statistics to analyze how many Drufo users develop non-Hodgkin's lymphoma compared to the number of non-Drufo users who got cancer.
And what did this data show you?
All of our data came in below a normal confidence level, meaning that people that use Drufo do not have an increased risk of developing cancer.
Thank you. Now, I would like to discuss the plaintiff's witness, Dr. Rogers' study concerning the relationship between Drufo and cancer. Doctor, can you explain in your own words the plaintiff's claim?
Dr. Rogers claims that there is a correlation between Drufo use and non-Hodgkin's lymphoma. However, these results are not accurate due to the fact that they were based on a flawed study.
And why do you believe Dr. Rogers' study was inaccurate?
Dr. Rogers compares the incidence rate of non-Hodgkin's lymphoma for people such as farm laborers and gardeners to normal people.
And why does that diminish the accuracy of Dr. Rogers' study?
Dr. Rogers is comparing apples to oranges. Of course, people like farm laborers and gardeners are more likely to get cancer because they work with products and chemicals and environmental conditions that normal people would never come in contact with. People in those professions have a higher likelihood of developing cancer solely because of their environment, not because they use Drufo.
And how would you have accounted for this to ensure that the study was accurate?
In order to make Dr. Rogers' study reliable, one must compare something like farm laborers who used Drufo to farm laborers who didn't use Drufo. This is the type of study that Lush conducted when we confirmed that Drufo did not cause an increase in cancer cases.
Did you observe any other problems with Dr. Rogers' study?
It is crucial to note that Dr. Rogers' study has not been peer-reviewed or replicated. All of his findings are based solely on his own biased conclusions and have not been confirmed by anyone else.
And why do you say Dr. Rogers' study is biased?
Dr. Rogers' entire career is to find the harmful effects of chemicals. If all he's looking for are the harmful effects, then that's all he's going to find.
Thank you. Finally, Dr. Williams, I'd like to return to your conclusions in this case. In your professional expert opinion, based on research and studies you've conducted, does Drufo cause non-Hodgkin's lymphoma?
I'm confident that it does not. There's no valid evidence to support this claim, and studies I've done and data I've collected show that Drufo is not only a safe product for humans, but a revolutionary product in keeping our planet safe.
Thank you. Your Honor, I have no further questions at this time.
Any cross-examination?
Yes, Your Honor. Doctor, you work for the defendant in this case, is that correct?
Yes, that's correct.
And you are a chairman on the board of this company?
I am the chair of the ethics committee at Lush, yes.
So your company, and therefore you, do have, however small, a financial stake in this case, is that correct?
It is correct that Lush does have financial incentives in this case, yes.
And you do as well?
Yes, that's correct.
And Lush performs in-house studies for their new developing products, correct?
Yes, we do.
And even if it didn't, an in-house study at Lush may possibly have bias in the results of those studies, correct?
I believe that the work we do at Lush is solely focused on creating accurate conclusions, and we only ever conduct truthful studies. So I don't believe a bias is a factor in the results of any of our studies.
But it's possible that bias could be present in any sort of in-house study.
I guess you could say that, but I don't think so.
And doctor, when did you begin working at Lush?
12 years ago.
And at that point, most of the Drufo development team had left the company, correct?
The original development team, yes.
And so you were not involved in the actual development of Drufo, is that correct?
Not the development itself, no.
And Lush fertilizer is also banned in the European Union, is that correct?
Unfortunately, it is, yes.
And the company chose not to fight this decision.
Yes, as I said earlier, at the time that that decision was made, we did not have the resources to fight that decision. So we decided to instead sell a product in the European Union that did not contain Drufo.
And you're conducting a new study and your company plans on submitting these new findings to the European Union for reconsideration on this topic, correct?
Yes, that's correct.
But however, the loss of this lawsuit could potentially create some roadblocks in getting this new approval from the European Union?
Unfortunately, it would, but luckily, as we've confirmed, Drufo is not carcinogenic, so I'm not really concerned about that.
Thank you. No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Dr. Williams, can you once again explain the EU's decision behind banning Drufo in France?
So the EU did not ban Drufo because of carcinogenic concerns. Rather, they banned it because of their nitrate directive.
Objection, Your Honor. This has been asked and answered.
Going to overrule it at this point. They're following up on the cross-examination.
Should
Dr. Go.
The European Union deemed that Drufo contained more nitrogen than its directive allowed, so they decided to ban it. But as I mentioned earlier, I don't believe that that was an accurate conclusion.
Thank you, Dr. Williams. No further questions at this time.
Thank you. The witness may be excused. Does the defense wish to call any additional witnesses?
Yes, Your Honor. The defense calls Skylar Weirs to the stand.
You may proceed.
Good afternoon, Ms. Weirs.
Good afternoon.
Can you spell your name for the court?
Yes, my name is Skylar Weirs, SKYLERWEIRS.
And why are you here today?
Well, I'm here to testify about Lush Incorporated and its product Drufo.
Before we begin, I'd like to touch on what the court has already heard from prior witnesses, that is, your relationship with the plaintiff. Can you describe the relationship between the two of you?
Yeah, so Dakota's my twin, and I love and support Dakota, but my research has shown that they're coming after a company that has nothing to do with their health problems. I support Dakota as my sibling, but I can't support their lawsuit against a company that did nothing wrong.
I'd like to talk about your background and experience. What do you do for a living?
I'm an investigative journalist for Rationalist magazine.
And what are some of the articles you've written?
Well, I spent almost a year writing essays about modern agritech, which led me to research Drufo for about a year.
And can you explain your research process?
Yeah, I look at publications from agritech companies such as Lush Fertilizer, for example, and information maintained and studies in those publications.
And what, if any, government publications have you reviewed?
I reviewed information maintained by the United States Department of Agriculture and the National Association of State Departments of Agriculture.
And Ms. Weirs, how would you describe your knowledge of modern agricultural technology?
My knowledge of modern agritech is very thorough. I have acquired modern historical and statistical information. After researching Drufo for almost a year, I have a deep knowledge of modern agritech.
Your Honor, pursuant to the pretrial ruling from the court, we needed to demonstrate 4 things in order for Skylar Weirs to be qualified as an expert regarding modern agritech. And those things that we needed to show are that Ms. Weirs spent considerable time researching agritech companies, that she reviewed publications written by those companies, and that she reviewed research studies referenced in those publications, and that she reviewed information maintained by the USDA and NASDA. And having done all 4 things pursuant to the court's pretrial ruling and Rule 702, we would like to admit Skylar Weirs as an expert in modern agricultural technology.
Any objection?
Yes, Your Honor. Permission to conduct a brief voir dire.
By all means.
Ms. Weirs, you do not have a degree from an accredited university, correct?
I do not, but I believe the information that I obtained could not be acquired by a college degree.
So then what knowledge and experience do you have in agritech?
Well, I'm an investigative journalist, and so I spent almost a year researching information about modern agritech. I went and visited modern agritech companies. I looked at studies and publications that they created, and I looked at information by government offices that contain information about modern agritech. All of this research took place in a full year, and so I have a very thorough understanding of this topic.
And can you define modern agritech?
Yeah, modern agritech is technology such as fertilizers, pesticides, GMOs, things like that, that help in the agricultural industry.
Your Honor, the plaintiff objects to Ms. Weirs testifying as an expert witness as she has not received education in her field of study and only knows about modern agritech because she has read about it in a book and reviewed other studies and has not conducted her own. Pursuant to Rule 702 of the Federal Rules for Civil Trial, an experienced witness must have knowledge, skill, experience, or training or education. Since Ms. Weirs has not proven that she is sufficient in these ways, as she has only read books, the plaintiff objects to Ms. Weirs testifying as an expert in this case.
Response?
Yes, Your Honor. In the court's earlier pretrial ruling, this court already stated that Skylar Weirs may be admitted as an expert, and all that's needed on the part of the defense is to establish the facts of her research. And as I believe we have done that in this trial, Ms. Weirs should be admitted as an expert.
At this time, I'm going to admit Ms. Weirs as an expert. As always, the plaintiff may cross-examine and impeach the witness on their opportunity to cross. Thank you.
Thank you, Your Honor. Now, Ms. Weirs, let's talk about the use of pesticides in agricultural products. Why are pesticides needed in agriculture?
Yeah, well, pesticides are designed to kill harmful bacteria on plants so that they're safe for human consumption.
And are any pesticide products completely risk-free?
Of course not. Pesticides are, by definition, poison, so there isn't a product on the market that's safe.
And why is that important in this case?
Well, Dakota Weirs worked in landscaping and was exposed to many different pesticides. Any one of those pesticides could have caused her cancer. There's just no way to know.
Now, let's talk about Lush Fertilizer's products and Drufo itself. What role does Drufo play in Lush's fertilizer?
Yeah, well, Drufo is a bonding agent that prolongs the effectiveness of nitrogen, phosphorus, and potassium in the soil. Drufo prevents these ingredients from washing away, and as a result, it only needs to be applied 1 to 2 times per year, as opposed to like 5 to 6 times per year for other fertilizers.
And why is that beneficial?
Well, the lowered solubility and required usage of Drufo.
Objection, Your Honor. This is outside the scope of the witness.
Please extrapolate.
Your Honor, this witness has been admitted in modern agritech. She is explaining the science behind it, and that does not fall into the modern agritech category. She is not a scientist.
Your Honor, may I respond?
Please.
Your Honor, the entire point of modern agricultural technology is that it delves deeper into the science and technology behind those different things such as GMOs, fertilizers, pesticides, etc., that enhance the agricultural industry. And as such, I believe that Ms. Weirs does have sufficient knowledge in this area to extrapolate on these subjects.
At this point, the witness has been endorsed as a witness, has been accepted by the court. Counsel, you are more than able to cross-examine her as to her credibility on cross.
Thank you, Your Honor. Would you like me to re-ask the question?
Yes, please.
And why is that beneficial?
Well, the lowered solubility and required usage of Drufo means it's less likely to contaminate groundways and waterways. It also ensures that other pesticides like glyphosate or arsenic aren't needed.
And why would a company prefer not to use glyphosate and arsenic?
Well, because the links between Drufo and non-Hodgkin's lymphoma are inconclusive at best. There are clear links between pesticides such as glyphosate and arsenic in cancer. In fact, the National Agency for Research on Cancer classifies arsenic as a carcinogen in humans.
Could a person have come into contact with cancer-causing ingredients like arsenic working at, say, a landscaping company?
Of course, and a lot more often than they'd see Drufo.
And what are some potential negative effects that could come from such exposure?
Well, one could get cancer or even non-Hodgkin's lymphoma.
And in your research, did you discover any link between Drufo and cancer?
No, in my entire year researching modern agritech, I could not find a single study that established a solid link between Drufo and cancer.
And in your expert opinion, to what extent, if any, could Drufo have caused non-Hodgkin's lymphoma in the plaintiff?
None at all. Drufo did not cause this illness in the plaintiff.
Thank you, Your Honor. No further questions at this time.
Any cross-examination?
Yes, Your Honor. Ms. Weirs, I want to start by talking about the articles that you write. You wrote an article on Monsanto, correct?
I have looked into the corporation Monsanto, but I haven't written any articles beyond what I've written about modern agritech.
I'm sorry, maybe you misunderstood me. Have you written an article on Monsanto?
I haven't specifically written an article on Monsanto, but I looked into it for my essays on modern agritech.
You wrote an article supporting Monsanto, a product that was proven to cause cancer, correct?
Objection, relevance.
Response?
Your Honor, I am simply trying to show that if Ms. Weirs was willing to write an article defending Monsanto, which was proven to be carcinogenic, then she's doing the exact same thing with Drufo. She's defending Drufo, which is carcinogenic.
Your Honor, may I respond?
Briefly.
Your Honor, with respect, I believe that the leap opposing counsel is trying to make is a rather large one. And especially in this case, we're talking about the carcinogenic possibility of Drufo. We're not discussing the carcinogenic qualities of Monsanto in this case.
I'm going to allow this to go towards credibility.
Thank you, Your Honor. So you have, let me repeat my question. You wrote an article supporting Monsanto, a product that was proven to cause cancer, correct?
I have not written any articles specifically about Monsanto, and I was not aware that it caused cancer. I have written about modern agritech, and Monsanto is included in that field, but not specifically, no.
Right. You have also written an article on Drufo, correct?
Yes, that was part of my series on modern agritech.
And in this article, you claim that Drufo is safe, correct?
Yes, that's because it is.
And you say that Drufo is a pesticide?
Yes, it's designed as a bonding agent and it's also an effective pesticide.
But you claimed in your witness statement that pesticides are by definition poison.
I mean, pesticides are designed to kill living organisms on plants, but when used correctly and wearing proper protective gear, they're perfectly safe to use for humans.
Moving on, you have never conducted any studies on Drufo yourself, correct?
No, my job is to look into studies by government agencies and agritech businesses.
So all of your knowledge on the safety of Drufo has been from interpreting other people's studies, correct?
Yes, they're very reliable studies.
And all of your knowledge on modern agritech has been from reading books and other people's studies, correct?
I wouldn't say books, I would say information maintained by agritech companies and government agencies, which are very reliable sources and do trustworthy quality research.
But none of your education has come from a university or class, correct?
Objection,
No.
asked and answered.
I'll allow it at this point.
Thank you, Your Honor. Would you like me to repeat the question, Ms. Weirs?
Yes, please.
In fact, none of your education has come from a university or class, correct?
No, once again, I believe that the work I do and the knowledge I've obtained couldn't come from a university degree.
A yes or no answer will do for this next question. All of your knowledge, not just on Drufo, but on agritech as a whole, has come from interpreting other people's information, correct?
Yes, that's true.
Objection, cumulative evidence.
Response?
I am simply asking a question based on the other questions that I've asked. I'm simply asking Ms. Weirs to draw a conclusion from the other questions that I've asked.
Your Honor, may I
Overruled.
respond?
Not at this time. Overruled.
Thank you. Your father was not pleased with your decision not to go to a university, correct?
No, unfortunately not.
And your father also helped you with your gambling debt until he became mad at you for not going to a university, correct?
Objection, lack of foundation.
Can you, what foundation are we missing in this council?
Your Honor, the opposing counsel hasn't gone into Ms. Weir's familial relationships at all and also hasn't addressed Ms. Weir's gambling debt, if indeed she has any, and defense would like to see additional foundation laid before opposing counsel delves into those topics.
Any response?
Yes, Your Honor, I think I have laid proper foundation. I talked about her father not being pleased with her decision not to go to university, and the result of that was her father did not help her with her gambling debt anymore.
Overruled. Please continue.
Thank you, Your Honor. But your father continued to help your sister with her medical bills, correct?
I mean, yes, I understand the reasoning for that. Dakota needs help, and I support his decision to help her be healthy.
But you were still not pleased with your family after this, correct?
I mean, I was disappointed to lose support from my family, but I understood the decision.
I want to go back to your articles really quick. You get paid for every article you sell, correct?
Yeah, I'm a paid professional writer.
And yet you say in your witness statement that you have to have 2 jobs to make ends meet, correct?
I mean,
Staff and students, please excuse the interruption. Our friends and partners at Broomfield High School has treated our school.
It's a curse of high school. You can't control the PA system.
Your Honor, before I continue, can I just have a quick time check? Stop. I believe it was put in the chat. I'm going to check it really quick.
I believe you have 6 minutes left on cross.
Thank you, Your Honor.
Oh, sorry.
You're good.
Please
Okay.
continue.
So, okay, going back to your family, you claimed in your witness statement that you and your sister are the sole beneficiaries of your father, correct?
Yes, that's true.
So to clarify, if your parents die, their money and possessions will be split between you and Dakota, correct?
Yeah, that's how that works, yes.
Since non-Hodgkin's is potentially fatal and Drufo is by your definition poison, if your sister dies, you become the sole beneficiary, correct?
I'm sorry, I don't believe that Drufo is poison. I believe that the pesticides involved in it can be used to poison living organisms, but I wouldn't say that Drufo is poisonous. That is correct, but I wouldn't draw any conclusions from that.
I'm sorry, can you please answer my question with a yes or no answer?
Yeah, can you ask the question again?
Yes. Since non-Hodgkin's lymphoma is potentially fatal and Drufo or the pesticide in Drufo is by your definition poison, if your sister dies, you become the sole beneficiary, correct?
That would happen, but I don't believe Drufo is responsible for Dakota's cancer, so yes.
And this money would be able to help you with your gambling debt, correct?
I mean, I guess so.
Objection, improper character evidence.
Can you extrapolate?
Your Honor, Ms. Weir's gambling debt can't go to show her character in this case.
Response?
Your Honor, I believe that it can. Because of her gambling debt, she had a falling out with her family, and it shows that she is upset with her family and has bias against her sister, Dakota Weirs.
Response?
Your Honor, my apologies. Is opposing counsel talking?
No, Your Honor. No, sorry.
Your Honor, in this case, I don't believe that using Ms. Weir's gambling debt as evidence that she would wish her sister to pass away is a reasonable question for Ms. Weirs.
I do believe it goes towards bias, and I will overrule the objection. Please continue.
Thank you, Your Honor. No further questions at this time.
Any redirect?
Briefly, Your Honor. Ms. Weirs, why did you choose to forgo college?
I mean, I chose to forgo college because my journalism career was really taking off, and I didn't want to lose out on an opportunity to chase my dreams just because I was trying to get a college degree at the same time.
And what would be your response to Drufo being, to accusations of Drufo being poisonous?
I mean, so Drufo is a pesticide, and pesticides are designed to kill bacteria on plants. But that doesn't have any correlation to them being harmful for humans. If people wear proper protective gear, use it in a safe way outdoors, Drufo is perfectly safe for humans. There's no need to worry about it causing cancer or anything like that.
And would you consider yourself to have any sort of personal or financial bias in this case?
Of course not. I'm testifying perfectly free of financial bias today as I'm a professional and an expert.
Thank you, Your Honor. No further questions.
At this point, I believe it's the witness can be excused. Does the defense wish to call any additional witnesses?
No, Your Honor. At this time, the defense rests.
Very well. I usually do offer the parties a couple minutes before closing arguments if you would like that. If not, I'm more than happy to continue.
Your Honor, we are ready to continue.
And for the other party, are you also ready to continue?
Yes, Your Honor, we are ready to continue.
All right, in that case, would the plaintiff like to make a closing statement?
Yes, Your Honor.
You may proceed.
Your Honor, members of the jury and opposing counsel, may it please the court, my name is Christopher Gudzik, and I represent Dakota Weirs in this case. We appreciate your attention throughout this matter, and we thank you for listening to both sides equally, as you promised you would do during jury selection. This case comes down to one thing: corporate greed. This case is about a company valuing its image and money more than the safety of mankind. Today, you have been shown beyond a preponderance of evidence that Lush Fertilizer was negligent in their inclusion of Drufo in their products. First, you heard from Ms. Dakota Weirs about how she was robbed of her livelihood because of Lush Fertilizer's product. She was on her way to becoming a musical genius. Then, playing piano, her one true love and sole remaining connection with her grandfather was stolen from her because of a fully preventable illness. Her main interest in her prosecution of Lush Fertilizer, in this case, is preventing any other people from this terrible fate that she suffers. Lush cared more about their profit than the value of human life, causing Ms. Weirs to lose her passion and her joy. Then you heard from Carson Durst, a chemical engineer that studied the effects of Drufo, about how Lush knew about the dangers of Drufo. They knew about the harm their product would cause, and yet they released it to the masses anyway. They knowingly and negligently sold poison for profit. Lush put the public in danger because of their greed and need for more. Carson Durst told you how Lush had the power to protect its consumers, yet they ignored that responsibility in favor of money. Then they marketed their product as being good for the environment in order to save their reputation. So instead, they harmed the public and they caused Dakota Weirs' illness. Skylar Weirs, an expert, even said that fertilizers are by definition poisons, and no fertilizer is 100% guaranteed to be safe. Lastly, Dr. Casey Rogers, an expert in the field of agriculture, horticulture, and even the effects on human body by chemicals, explained Drufo's dangers. He explained what Drufo is, why it's so dangerous, and even the danger it causes. Dr. Rogers conducted and controlled a scientific study that clearly showed that Drufo causes non-Hodgkin lymphoma. And non-Hodgkin lymphoma is caused by environmental factors. Drufo is one such factor. And Dakota Weirs was in an environment with Drufo for an extended period of time. Dr. Rogers clearly demonstrated that Lush Fertilizer caused Ms. Weirs' illness and the pain it causes her. Lush knowingly made fertilizer with poison that causes cancer, and Lush chose not to warn its customers. If what Mr. Doncourt said was true, and consumer safety is Lush's #1 concern, then a more in-depth warning label and information to the public should have been apparent. Life is precious, but in Lush's opinion, not more precious than money and a good reputation. Drufo is a dangerous chemical that cost Dakota Weirs everything. Her life is ruined because of Lush's negligence. Thank you.
Would the defense like to make a closing argument?
Yes, Your Honor.
Your Honor, I apologize. Can I just confirm that any extra time has been reserved for rebuttal close?
That's fine. Thank you.
Thank you.
May it please the court, counsel, members of the jury. This case is about an unsafe employee, an unconnected illness, and an unbelievable accusation. Now, in order to prove their case, the plaintiff needed to prove by a preponderance of the evidence that 4 things were true in this case. Now, let's stop and talk for a second about that word, preponderance. It's a big word, but here's what it means. It means that there's just a 51% chance, even 50.1% chance that the plaintiff is wrong, or they haven't proven one of the 4 things they needed to prove, then you must reach the verdict for the defendant in this case, Lush Fertilizer. So let's walk through those things, those 4 things they needed to prove, and see which one fills that test. Now, the first thing the plaintiff had to prove is that Lush Fertilizer manufactures a fertilizer that contains Drufo. That part is easy. Not only does Lush Fertilizer admit to manufacturing a fertilizer that contains Drufo, they're proud of it. Why? Because Drufo is going to save the planet. It means less applications, less nitrates, less algae blooms, and less damage to the environment. As you heard from Lush CEO Blake Doncourt, that's something that the company cares truly about. But that's where the plaintiff's case ends, because the next thing they have to prove is that Lush failed to take reasonable care to protect against unreasonable harm. Now, you know that Lush acted reasonably because you heard from Blake Doncourt, who told you that Lush had done careful studies and analysis and verified that Drufo was safe. You heard expert testimony from Dr. Devin Williams, who confirmed that not only is Drufo safe, but will revolutionize and transform the negative impacts that fertilizers of the past have done on our planet. And you heard from another expert, Skylar Weirs, the plaintiff's own sibling, who told you that the benefit of this product is that it causes less harmful exposure to humans. Indeed, Skylar Weirs testified that if you're looking for a clear link to cancer, look to some of the many other pesticides on the market, which leads us to the problem of causation. Not only does the plaintiff need to prove that Lush acted unreasonably, but in doing so, it caused Dakota Weirs harm. Has the plaintiff been able to do that? No. They have not provided one piece of evidence, one document, one witness that can definitely show you that Dakota Weirs' illness was caused by Lush Fertilizer. What did cause Dakota's illness? We don't know. One of the countless other chemicals Dakota worked with on her job, a job that Dakota conducted in an unsafe manner. You heard Dakota testify to working without the necessary precautions, the recommended precautions to prevent being harmed by countless other chemicals she was working with, chemicals which do cause cancer. Finally, Dakota Weirs' illness is tragic. Cancer is tragic. But millions of people all over the world suffer from cancer, thousands from non-Hodgkin's lymphoma. Yet Dakota's doctors feel like Dakota could make a full recovery. Dakota could still play the piano, still go to school. But Dakota Weirs is coming today asking for money. Money for a maybe unsafe employee based on an unbelievable accusation for an unconnected illness. Ladies and gentlemen of the jury, you've heard the evidence. We ask that you find for the defendant in this case. Thank you.
I believe that concludes the trial today. I want to go ahead and thank everybody for...
Your Honor, may I have...
I apologize. Your rebuttal argument, please.
No problem. Before, could I please get in the chat exactly how much time I do have? Thank you. Your Honor, the defense says that Dakota Weirs' development is unconnected to Drufo, and that's simply untrue. Fertilizers are pesticides and thus poison, and people's safety cannot be guaranteed. Over 50%, even 50.001% of the evidence has shown that Lush Fertilizer is responsible. The 4 things that the defense, the 4 points that we were required to prove have been proved. 1, yes, Lush does produce Drufo. 2, Lush did actually fail to take the proper safety precautions in that they merely had a warning on a misprinted warning label, and they really didn't enforce as much as they could and should have. The third thing is that the plaintiff did prove that Drufo has an increased risk of cancer, and the defense has even said that working with chemicals can cause cancer, and the chemicals that Dakota worked with did cause cancer. And the fourth thing, Dakota Weirs is not specifically asking for money, but any money she does receive is for her medical bills that she uses for her cancer and for compensation, if she even receives any money, which she did not ask for. It is over a preponderance of evidence in the four things that need to be proved. Thank you. No, thank you.
All right, at this point, that does conclude the trial. Again, I want to thank all the students for doing such hard work to prepare for this. I think it's an incredible thing. That said, I know that we do need to have the scoring be done before any commentary is made. So I'm going to ask everybody just simply hang out for a second while the scoring jurors get their submissions entered.
Okay, we did receive all of your score sheets, so we can go ahead and get started with the feedback.
So if any of the jurors would like to give any feedback, I usually let you folks go first. It's up to you. No pressure if you don't want to give any feedback.
I'll go first.
Okay.
I like to go first. So good morning or good afternoon. My name is Keisha Cook, and I'm an attorney here in Colorado. Congratulations on round one of state competition. State is always my favorite activity to do with the Colorado Bar Association. You all did a fabulous job today. I just want to give some general feedback to you all. Loved the theme. From the very beginning, you both had solid themes and they were repeated in the closing arguments. That's great to see. One bump in performance that you might want to consider is bringing that theme out while you're crossing and doing your directs. For example, for the defendant, you had that theme of unsafe employee, unconnected illness, and unbelievable actualization, I believe. And you could have brought each of those like in part of your chapters as you're doing your cross-examination or your direct, you could have brought some of those things in so that the jurors are reminded about that theme. Just consistency throughout is a great idea. Great job on your directs and on your opening statements. You guys all have the skill necessary to be at state. One enhancement I would add is I think it was more beneficial or more persuasive when you did stand up. So for the team that chose to sit down, you might want to think about standing up, getting into the spirit of the competition and the performance aspect of it, especially on your openings and closings. That might help you. The other thing is movement. Miss Balaji, did I pronounce that right? You had great movement. You were very deliberate. A lot of the time you had lots of hand motions. They were deliberate most of the time. You would always come back to here and then start again. You might want to just slow that down a little bit because there were times where it was getting a little bit distracted. Also, your body was kind of moving with you at the same time. And I think it was because you were trying to give, varying positions, like this is what the plaintiff's going to say, this is what the defendant's going to say. Maybe be even more deliberate. I'm over here, this is what the plaintiff's saying and all of her arguments. Then you move, this is what happens when we're electronic, right? Then you move over to the other side and you do the defendant as well. The other thing I just want to talk about, cross-examinations. Man, This is really where you can distinguish yourself between the competition. It is about witness control. At this juncture, all of the witnesses are very good. They are almost as good as attorneys, right? As far as like being able to, oh, well, that's speculation, things of that nature. And they're not going to give you a good, correct, yes, no. So it's all about witness control as much as you can. I saw some moments of real brilliance around that, but that's definitely something that both sides can work on. And wow, cross-examination, you guys were so damn polite. Like at the very beginning, you were saying, oh, good morning, how are you? I just want to tell you how much my sympathies are with you. And then you proceed to tear them apart. It's just a bit of a, it's a bit disingenuous, to tell you honestly. And I'm like, and it's a waste of time. I think you guys got very close to the time end. Just cut out all those niceties. The other thing that I saw was that when there was an objection, or if there was a pause in the action and the question needed to be re-asked, you all asked, do you want me to repeat the question? If it's a great question, right? If it's a question where it's going to show the bias of the individual, or there were a couple of times when you're like, you were disingenuous, or your gambling problems, things of that nature. Those are great points to just ask the question. Don't ask the witness. Get your opportunity. You won the argument on your objection. Repeat the question. Don't ask for permission. If you're the witness, say no. Don't say yes. Please do repeat the question, because that gives your person on the other side an opportunity to put out their story as far as the case is concerned. Overall, very good performances by everyone. I've loved the witnesses, especially the experts. Good job. And that's all I've got. Thanks.
Jason, you want to go next?
Sure. I guess Keisha's a little smarter than I am. Going first, you get all a lot of the same points that I was going to make. I guess to reiterate the question of would you like me to repeat the question? And the time you taken to say that, you could have just asked the question again and highlighted your story or your case instead. A lot of the same comments. There was one question I thought was very interesting about under directed, or it was on cross on Luke. You were basically said you lied in your covenant not to compete, and you admitted that you lied. I understand where this is all hard to do, but don't ever admit to lying, because then that destroys your credibility as a witness. But just moving forward, just think about that. I thought it was interesting as far as generally strategy-wise. I don't know what use the covenant not to compete really has per se to the value of whether or not this did or did not happen, whether or not there is or isn't liability on one side or the other. Both teams used a lot of time on the covenant not to compete, and I don't quite understand here what relevance that has. But understanding, you're already here at state, may be hard to adjust, but something to consider. You might have other pieces of your case that are more valuable to spend your time on. And I also just realized I didn't introduce myself. Jason Myers, I'm a town attorney, municipal government attorney. I've prosecuted for about 7 years as well. So that's a little bit about my background. And then last piece I would add during the closing, I guess both sides kind of mentioned the burden of proof a little bit, but then kind of conflated that we've proven. And it's hard sometimes for a jury to understand what those differences are. So you don't have to prove something. You just have to, in this civil instance, you're saying it's more likely than not, or it's less likely. So you don't have to say we have proven that it did this. We've just shown, the evidence has shown that it's more likely than not that this is the case. So make sure that you're not inappropriately on the plaintiff side of things, saying that you've proven more than you have, because I think a juror would say, no, that's not true. And then on the defense side of things, you want to make sure you're not saying, changing what the burden of proof is to something higher. So those are my points. I think you did a very, very good job. I've always loved judging these, or as a scoring panelist, been doing it for several years. So you guys did a great job. I understand it's difficult via Zoom and some of the technical issues, and not being able to be physically in a courtroom and have that opportunity to walk around and all those things. But commend you. You all did a very fabulous job, and I appreciated that I got to participate. Thank you.
All right, I guess I'll go next. I'll try to be brief as well. I know you have another round today. My name is Mark Pullman. I taught legal studies and coached college mock trial for more than 30 years at Rhodes College in Memphis, Tennessee. 4 years ago, I retired to Denver and have been here ever since. I also, back in the day, coached high school mock trial for 4 years. So I have some familiarity with this endeavor. 4 quick points. First of all, a general comment. I've judged a bunch of remote college mock trials as well. As this problem there also. Be careful when you're on Zoom to not come off as too scripted. We can actually see your eyes move as you follow your script. And if it's too ready, if your question is not conversational and too ready, the answer's too ready, it just hurts the whole credibility of the exchange. So if you can slow it down a little bit, talk like human beings and like you're having a conversation with each other, and it will come off as more spontaneous, less scripted. I also think in openings and closings, if you can actually quote from something the other side said or just said, it makes it look less scripted. It makes it look like you're actually responding to what's happening in the trial. And that will help make you stand out from some of the other attorneys. There's a comment that we get in the judge orientation that you should be aware of. And they tell us to be careful that you're not arguing in your opening statement. And I think both sides did actually argue some in your opening statement. Remember, that is a statement, that's a roadmap for what's to come. We don't have any evidence yet. So to reach conclusions about what happened and who's guilty and so on is premature. So be careful, little thing, but be careful not to argue in your opening statement. Save that for your closing argument, right? And because the judges are tipped off to that, we're listening for it. Witnesses. Some did this very well, some maybe slipped a little bit. One of the things we watch as judges is, are you getting defensive under cross-examination? Does it look like the cross is getting to you? Are you changing your demeanor? Are you getting testy? Are you using too many buts? I answer, but this, but that. What's the problem there? It hurts your credibility. Other than the defendant, nobody has a dog in this fight. You shouldn't ever come off as if the cross-examiner has shaken you or you're trying to defend what you've said. Sure, you want to defend what you said, but you want to do it in a way that sounds like that's not what you're doing. So always try to appear like you're agreeing. Yeah, I see your point, and this is why I said this. So you don't look like you've been shaken or are on the defensive. Last thing is objections, and this is one of my pet peeves. I think generally mock trial attorneys assume that they score points by making objections. You do if they are good objections that the other side doesn't have a ready response for. Realize things like relevance are an awfully low bar. You make a relevance objection, the other team is going to come back. They could explain their whole theory of the case to you. Well, it's relevant because, as we told you in opening statement, they can walk right through it and then explain why that witness is on the stand. Be real careful with things like relevance objections, unless it's just absolutely a non-germane. And the upshot of that is when you make an objection, you may make the opposing counsel look better than you in the response. So as a strategic matter, I would make fewer weak objections. If a witness is killing you and you want to break the flow, okay. But overall, most of the objections I heard did not really help the objecting attorney very much. There were a few that were on point and kept out testimony that should have been kept out. But overall, be careful when you make objections because they can hurt you more than help you. That's all I got.
All right, well, I'm going to go ahead and tie right into what Marcus just mentioned. You guys got to be careful with objections because this is something that I know when I was in law school, and it's been many, many years. So I'm Chris Corkadell. I'm a defense attorney for criminal defense work here in Denver. I've been doing this for 16 years, 17 years. I just have very good skin cream. And so what I will say is I always wanted to object because I just wanted to object. I looked for that question. I was like, they asked that same question 4 minutes ago. I'm going to object. It's not effective. It hurts you. It gets the jury members to be angry towards you for wasting their time. And the other thing is that almost all judges that I've known will literally allow those questions asked and answered in to give context to the following question. Okay, so you say, so earlier you said this. Okay, yes. Now they follow up with a different question. And by objecting with asked and answered, it's honestly bringing focus to that question for the jury because they're like, oh, so what's going on here? What are they trying to hide? And it doesn't do you as much as you would like to have it be effective on it. Don't worry as much about introducing yourself. I know that everybody, when you think about lawyers, you think the epitome of prim and proper, always formal 100% of the time. The best trial lawyers I've seen ever in my entire life walk into a room. They are kind, courteous, and they have confidence that's an easy confidence where you watch them talk. And the next thing you know, you're like, I want to be friends with you. And I like what you're saying. And you don't have to say, may it please the court, the jury, opposing, honestly, forget opposing counsel. They don't even matter. They're unimportant all the way across the board. You don't have to worry about your name. You don't have to worry about anything about you. You aren't the star. The star is your client, your theme, whatever it happens to be. So focus on that. Let go of some of the formality. It will work. The greatest compliment I was ever told once was I was cross-examining someone and I had them in such a flow that afterwards another prominent attorney came up to me. He's like, you just testified. As the attorney, you just testified. And it is the best thing you can ever do on cross-examination when you get them into a rhythm, into a flow, and the jury's listening not to what the witness is saying, but just to your side. I also want to say, I know that Keisha talked about standing up versus not standing up. There is always that struggle that you have right now where you have a microphone that doesn't move with you. And so if you stand up and back away, we may not be able to hear you. So I understand that it is more persuasive. It is absolutely more persuasive, but you do have to play to your technical limitations. And I have to really compliment everybody on not getting flustered when there were technical problems. I have seen people come into these competitions and fall apart when their tech doesn't work. And you guys just said, Your Honor, can we have a moment? Great, you got it taken care of and you jumped right back into what you were doing. And I really appreciate that. I think that everybody looks at that as a very difficult thing to be interrupted and to keep going. From the ruling judge perspective, look, I sometimes will give you the rulings that are right. Sometimes I give you the rulings that are wrong just to see what you do with them. I won't exclude your closing argument, but I will literally let you do things and just to see what you adapt to and how well you can adapt. So understand that that's going to happen through this entire process. And if you have a bullet point script that you are going to follow question to question, it is going to get ruined. Always plan to have one safe, powerful question to end on. Okay, because I've even had it happen to me. I go in, the judge excludes my entire line of questioning, and you just sit there and you say, well, actually, I guess I'm done, Your Honor. You never want to end with that. So just always make sure to have one safe, bulletproof question that you can end on. But otherwise, I really think you guys all did a great job, and I wish you the very best of luck going forward. I think you got a great start ahead of you.
Hey, Judge, at this point, do we get to know who the teams are, or are we not allowed to find that out?
You'd have to ask the other people who are, that's above my pay grade.
Competitors.
I find out at the end who wins usually. That's what I get. So
You get your
you can
score
ask
and-
in the other lounge if you want to jump back in to the judging and scorers lounge. They may be able to give you that answer. Okay.
Sounds good.
All right. Good luck on your next round, everyone.
Thank you.
Thank you.
Thank you.
Thank you so much to all of our volunteers.
Thank you.
Thank you.
We appreciate